Hi, my name is Kim Savage, and I'm an attorney from Michigan. My background is in utility real estate and right-of-way. I worked for 14 years for Consumers Energy, who's a major gas and electric distribution utility in Michigan, and another 2 years after that for ITC Holdings, which is an electric transmission company at that time in Michigan, now pretty much all over the country. I got the opportunity to represent, I'm now in private practice, I should say that. That's fairly obvious, but I'll put that out there. Been in private practice since 2009. And in 2012, I got the opportunity to draft an easement for an intervener in a public service case in order to settle his file. After that, I was asked to speak to landowner groups, and it really became evident when I appeared and simply explained what easement language meant to people, what kind of a need there is out there to understand what those documents mean and how little landowners really know. So what I've brought today is some suggestions. I ended up representing 70 landowners approximately on the Line 6B replacement project between Ortonville, Michigan and Stockbridge, Michigan, Phase 1. And I'll tell you that I made a lot of friends with the people that are working in Howell and Enbridge, and in general they're good people. But I'll also tell you that when they get out in the field alone with landowners, they don't always behave particularly well. And I think there are some things that we could do to make it better. I'm a transactional attorney. I don't litigate. I didn't expect to take a single client into condemnation, and I ended up taking 40 in because we couldn't resolve it. Basic issues. So here are my suggestions. Number one, if there are any industry people in the room at this late hour, please impress upon your right-of-way agents that it doesn't help. The spin doesn't help. Tell the truth. Tell the bold, honest, nothing but the truth. This is going to be terrible for you. And it's not going to be pretty. It's going to be inconvenient. Answer their questions. God's sakes, answer their questions. They know when you haven't followed up with them. And that's the one thing that is going to cause them to distrust you more than anything in the preliminary stages. If you don't know, say you don't know the answer and get back with them. I understand a lot of right-of-way people that are working in the field these days didn't always work in right-of-way. So they may not know the answers, but they do need to find the answers. Never mislead, and for God's sakes, never threaten. There is a statute in Michigan that requires utility companies to explain landowners' rights under the Condemnation Procedures Act. The way that was carried out in our case was a copy of the statute was handed down, and there was express threats to condemn in every case. I went back to Consumers Energy where I worked, and I said, why is that a terminable offense for our right-of-way agents? Why can't they threaten condemnation? And the real estate people there told me, well, Kim, it's because it really doesn't work very well. And I think that's very clear from what we experienced. Second, I implore you to seek community input. This is something that ITC does very well. And it's something that I bristled against when I got there. I came from a traditional utility, and I really didn't want to go take the heat at landowner meetings, and I had to. But in the end, we built projects that were very contentious. Apologize when you need to. I've got way more material than I have time, so I'll just be brief and say keep your promises. Put them in writing. If you mean to enforce them, why would you be opposed to putting them in writing? And don't make landowners litigate them when you break the promises. Make them right. People are talking. The internet makes that very possible now. If you offer somebody a $10,000 concession to sign, everybody knows that immediately. So plan on offering that to everybody, and if you don't expect to get signatures. Finally, and this is my most important point, many of you have probably seen my son in the audience today, and I'm constantly thinking, who raised these people? Because you're coming onto landowners' properties. This is their home. I understand it's your easement right, but it's where they live, and you need to show some respect. There are people urinating next to porta potties that are at front doors. There are trucks running all night and day. People live there. You know, take your shoes off when you walk on the property. Act like your company. You know, even if that's not the way you really feel, even if we know that legally that's not your position. And finally, most importantly, my personal opinion was I was there was a concerted effort to run me off the project. That may be my own paranoia, but my own position on this is there is extremely unequal bargaining power here, and it behooves you to advise people to seek the advice of counsel and consider paying reasonable costs for that. You'll have a better project. Attorneys are, in general, easier to deal with than emotional landowners. No offense to any of those people in the room. And that may be all. Thank you.